Giuseppe, thank you. Ladies and gentlemen, on behalf of Hamline University School or Faculty of Law, I would also like to welcome you to our program this afternoon. This is indeed a very important part of the law faculty's operations and aspirations to educate lawyers and to deal with significant issues of law and policy throughout the world. It is particularly a pleasure in the 5th annual program to be in such a beautiful environment, and we are very grateful to the hospitality that we have received here in Italy, in Rome, and especially here in Bologna. It is, I think, particularly appropriate, given the comments we heard a moment ago, to understand the importance of having legal education as a partner in these kind of programs. As was highlighted in the previous two speeches, there are a great many fundamental issues that go on at the heart of the philosophy underlying the practice of alternative dispute resolution, and it is the marriage of the practice and the skills along with the critical analysis which is central to continuing to develop this as an area of expertise, not just a technique. And I'm very proud of Hamline for having led the way in developing that critical assessment, that thoughtful approach to dispute resolution. I am also particularly struck by today's program in terms of two underlying themes that are particularly important to legal education, both in the United States and throughout the world. And those two themes are, first, the international aspects of law, and second, the transactional aspects of dispute resolution and lawyering. On the international perspective, it is vitally important that Americans and indeed, I think, lawyers from throughout the world, and particularly students throughout the world, recognize that today, unlike ever before, we truly are in a global economy such that the rules and the practices that one learns must be taken in the context of the global environment. That it is not enough to simply understand one's domestic laws, but rather one must understand the context of those laws across the map. Secondly, from an educator's perspective, the marketplace of ideas is incredibly enriched by having the opportunity to compare and contrast one's own legal system with the legal systems from other countries, to understand that there are differences between civil law and common law, there are differences in procedure, to force us to critically assess not just what, but why our institutions have made the choices that we have made as to what the fundamental rights are, as to what the procedures are, as to those laws which we consider the important laws at the heart of each of our legal systems. Through this comparison, I believe that students learn a much greater respect for the rules of law and a much more critical eye to what works and what doesn't work as we move from jurisdiction to jurisdiction and look for continual refinement in the rule of law so we can deliver good legal services and good fundamental laws to our citizens. But finally, in contrast to that position, I have found that as I have had the opportunity to work with lawyers from very many different nations and to look at a wide variety of legal systems, that we are coming to the conclusion that there is indeed a foundational level of law. There are certain choices that have been made using very different legal systems, using very different language to identify them, which nonetheless result in the same principles of justice existing in one legal system after another. That in fact there are fundamental self-evident truths to the law which are available to virtually every citizen of the world. The opportunity to have exchanges in this way, to identify what those fundamental rights are, improves each of our legal systems and ultimately will improve the legal systems of those countries which are struggling to redefine their rule of law and access to justice for their people. So the international aspects of what we do are a critical part of legal education at Hamline in the United States and throughout the world. The second important factor here that I see is the emphasis today on dispute resolution and transactional lawyering. And I tend not to use the word alternative because it really is a continuum and not a dichotomy. Particularly in the United States, but to a certain extent in many countries of the world, lawyering and legal education is often focused on courts and access to the approved dispute mechanism. Nonetheless, the actual role of law in most people's lives is focused on the rules of law that allow people to get along, the rules that allow transactions to take place, perhaps in the shadow of legal standards, but not governed by them, governed by the interactions between one person and another person. Taking the time to educate students, to educate lawyers on how important that aspect of lawyering has become, I think is a fairly revolutionary change to the education of law. It is a change that has occurred in the United States only recently and is starting to flourish in other parts of the world as well. But it is a critical step forward in understanding the role of lawyers in society, because the role of lawyers in society, in fact, plays a much smaller place in the representation before a court, the representation in a criminal setting, and much more in the structure of law and the opportunity for entrepreneurs, the opportunity for businesses to create positive relationships by and among each other. This conference represents a wonderful opportunity to explore those themes and to identify how we can best create opportunities so that the role of lawyering becomes increasingly transparent and the opportunities for our clients or partners in their enterprise becomes the primary focus. Having explained my approach, it is therefore a particular pleasure to now switch roles and serve to introduce our keynote opening address by Professor Richard Schell. Professor Schell is a professor at the Wharton School of Business at the University of Pennsylvania. And you can see from my appreciation in transactional lawyering that it is indeed a privilege to introduce a professor to us that has focused on the business rather than the legal aspects of our practice. Nonetheless, I would be remiss if I didn't note that he is, of course, a lawyer. Professor Schell received his Bachelor of Arts from Princeton University and his Juris Doctor from the University of Virginia. He then went on to clerk at the First Circuit Court of Appeals in the United States, and then became an attorney with the firm of Hill and Barlow in Boston, Massachusetts. Before joining the Wharton School, he first taught at Brandeis University and has also visited at the Harvard University School of Law in their Harvard program on negotiation. He joined Wharton in 1986, where he is currently the Thomas Garrity Professor of Law and former chair of the Legal Studies Department. His publications, just to give you a sample of his recent books, include Make the Rules or Your Rivals Will, The First Law of Business, which came out in 2004, and Bargaining for Advantage, Negotiation Strategies for Reasonable People from 1999. Professor Schell is currently working on models for understanding the importance of legislative, regulatory, and litigation forums in the formulation of business and competitive strategy, writing a book on the psychological powers and of the expectation of the participants in business. It truly is my pleasure to introduce Professor Richard Schell. Thank you. You're going to mention